Weiss+Associates presents Legal Facts about the Social Security Number. As children are born into a family, there's a lot of euphoria for those who love their newborn. The focus for the mother, who is now postpartum, is to nurture the infant. Today, hospitals routinely perform all the needed support for the delivery and testing of the newborn. One of the less well-known functions is the presentation to the mother of a set of documents which include the Form SS5 to complete for the federal government. Most American nationals, those who are born in the constitutional republic, the current 50 states of the Union, without a moment's thought, fill out Form SS5 for their newborn as if they're required to do so. Perhaps a quick review of the laws around the federal income tax and the Social Security number relationship to that tax should be discussed briefly. 1. The Supreme Court in Pollock v. Farmers Loan and Trust Company decision in 1895 informs American nationals, those born in the constitutional republic, that any income tax is a direct tax and must include the rule of apportionment, or else such a tax is unconstitutional. 2. The wording of the 16th Amendment states, "The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration." 3. The legislative intent of the 16th Amendment, written by President William H. Taft in 1909 and published in the Congressional Record of the U.S. Senate, states the following. The Pollock decision was held by the Supreme Court to be a direct tax, and therefore not within the power of the federal government to impose, unless apportioned among the several states according to population. 4. Taft continued with, "The decision of the Supreme Court in the income tax cases deprived the national government of a power which, by reasons of previous decisions of the court, it was generally supposed that government had." 5. Taft summarized his statement to Congress on the federal income tax as, "I therefore recommend to the Congress that both houses, by a 2/3 vote, shall propose an amendment to the Constitution conferring the power to levy an income tax upon the national government, without apportionment among the states in proportion to population." And 6. The national government, noted as the 10-mile square in the U.S. Constitution, was the targeted jurisdiction for the imposition or levy of the federal income tax. It does not include the constitutional republic, where American nationals live and work in the private sector. This is a separate jurisdiction, and American nationals are non-resident and alien to that federal territorial jurisdiction, the 10-mile square. So, we see that the federal income tax was only levied upon the national government. Its attempt at levying the federal income tax upon American nationals was deprived by the U.S. Supreme Court if the action to levy were to be done without strict adherence to the rule of apportionment. The 16th Amendment for the imposition of the federal income tax was established by the U.S. Congress as written. The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. This is truly stated, but you have to ask, is this actually a statement of the truth in regard to the constitutional republic? The reason is that the Supreme Court deprived the national government of any power to do such without the inclusion of the rule of apportionment, as admitted to by then-President Taft. The confusion for many is their lack of awareness of the jurisdiction to which the 16th Amendment was directed toward. Reading the 16th Amendment again, you see the willful and intentional action of the U.S. Congress to exclude the rule of apportionment, and also that amendment doesn't state the jurisdiction within which it's only applicable. That singular jurisdiction is only the 10-mile square and its U.S. territories. By now, you're probably thinking, I thought this was a narrative on the Social Security number. Good question. Here is the intersection of the federal income tax and the Social Security number. If you read 26 CFR section 301.6109-1, identifying numbers, you'll see immediately at A1 the reference to taxpayer identifying numbers. One of the principal types is the Social Security number. In this administrative regulation, you'll also find stated at G1I this general rule. A Social Security number is generally identified in the records and database of the Internal Revenue Service as a number belonging to a U.S. citizen or resident alien individual. Remember the presentment to the mother of the newborn? The Form SS5 was presented, and the mother or both parents simply assumed that they must fill this out. Two events occurred when they did. One, the child was converted into an involuntary indentured financial servant of the national government, or simply stated, a U.S. taxpayer. The statutory term U.S. citizen was defined by the national government to mean, per 3C Amjur 2D Section 2689, who is born in the United States and subject to United States jurisdiction to be. A person is born subject to the jurisdiction of the United States for purposes of acquiring citizenship at birth, if his or her birth occurs in territory over which the United States is sovereign. Accordingly, 2, the newborn which was born in the constitutional republic, but by issuance of a Social Security number, which there's no law requiring such, the child was converted into a statutory U.S. citizen. Thus, the child was not identified as an American national by the Form SS5, but only as a statutory U.S. citizen. All statutory U.S. citizens are considered by the national government to be a type of U.S. taxpayer. That child is now under the dominion and control of the national government, as are all those born in the territorial United States. As stated in 26 CFR Section 1.871-1A, resident alien individuals are, in general, taxable the same as citizens of the United States. All this and much more occurs when the parent or parents of the newborn sign that child into the Social Security system. Many American nationals are stunned by this discovery. The District of Columbia is not a state of the Union, nor can it ever become one. It represents a territorial jurisdiction established by the U.S. Constitution for the national government to act as sovereign over that territorial jurisdiction where the federal income tax only applies. Those American nationals born in the constitutional republic at the age of accountability should know that instantly they retain their sovereignty. They are neither of the subject nor of the object of the national government, nor its territorial revenue laws promulgated in the Internal Revenue Code. This is why President Taft made the admission, as he stated in the legislative intent of the 16th Amendment, that the government was deprived of any power to levy an income tax upon American nationals. Keep in mind that the Social Security Administration has openly stated in multiple response letters to American nationals from their Office of Public Inquiries that the Social Security Act does not require a person to have a Social Security number to live and work in the United States, nor does it require a Social Security number simply for the purpose of having one. Then the real impact is clearly stated by the Social Security Administration. Other laws require people to have and use Social Security numbers for specific purposes. For example, the Internal Revenue Code, 26 U.S.C. Section 6109A, and applicable regulations at 26 CFR Section 301.6109-1D require a person to get and use a Social Security number on tax documents and to furnish the number to any other person or institution, such as an employer or a bank, that is required to provide the Internal Revenue Service information about payments to that person. The only parties required, as stated by the Social Security Administration letter, is for those who are statutory U.S. taxpayers. Such U.S. taxpayers are listed by the IRS on instructions for Form 8938 FATCA under specified individuals. 1. Those who work for the national government in some type of public office. 2. Those who are statutorily defined as U.S. persons per IRC Section 7701A30. 3. Those who are U.S. resident aliens from a foreign country. 4. Those who are non-resident to the federal territorial jurisdiction and elect to live in a U.S. territory. And 5. Those non-resident alien individuals, meaning American nationals, who were duped into making an election declared to be voluntary by the IRS, but did so without any full disclosure of the ramifications of the adverse impact on their financial earnings over a lifetime, thus making the election one without any willful and knowing intent, which is to say, under fraudulent acts established by the U.S. Congress. Returning to the opening comments on the childbirth and the filling out of the Form SS5, more than likely both parents use an SSN in their personal lives and thus think nothing about it. Keep in mind that the Form SS5 is a federal form. Here's what the form asks if you have not seen one in some time. Notice that item 5 addresses citizenship. It shows several types. 1. U.S. citizen. 2. Legal alien allowed to work. 3. Legal alien not allowed to work. And 4. Other. Test yourself real quick. What at first glance is the response that you would likely select on this form? Most see the first choice and immediately are drawn to select that one. It's a reflex selection compared to the other choices. Now that you've viewed this Form SS5, did you notice the definition for the expression U.S. citizen? You won't find the definition as it's not stated. This is the beginning of a trap set in place with the introduction of the Social Security Act. Keep in mind the federal definition for the expression U.S. citizen is found at 3C Amjur 2D Section 2689 and is stated to basically mean one who was born in territory belonging to the U.S. government and are those subject to the dominion and control of the U.S. Congress. Confucius, a Chinese thinker and philosopher, is credited for saying, "When words lose their meaning, people lose their freedom." His statement reflects the general conclusion when one ceases to have an idea of what a word is intended to convey, and as such, the power to act as you want is lost. That should be a warning sign to stop completing this form for your newborn. If you were to ask anyone in the hospital for the meaning of U.S. citizen, they would probably state, someone who's born in the United States, and think privately that you're a few bricks short of a load. Of course, the hospital personnel are more than likely unaware of the existence of 2 United States, and that the Form SS5 only applies to the limited federal territorial jurisdiction. So, who are you going to listen to if there's no one to ask for a definition? Probably the vast majority of new mothers will simply select the expression U.S. citizen and think nothing about it ever again. But some may have a nagging feeling that something is just not quite right with the choices, and certainly that the federal government and the Social Security Administration failed to define exactly what the expression U.S. citizen means. For a detailed discussion on the differences between the 2 types of U.S. citizen, please review our video on Are You a U.S. Citizen? In brief, there are 2 types of U.S. citizen. One is the federal U.S. citizen as referenced on the federal form SS5. But the government doesn't want to draw your attention to the fact that they can absolutely control the life of those who make this selection. This definition is found at 8 U.S.C. Section 1401A and is better described at 3C Amjur 2D Section 2689. The Form SS5 is addressing only those who are born in one of the federal territories and are subject to, meaning under government dominion and control, the jurisdiction of the U.S. Congress. This selection identifies the party name as one who is the property of the U.S. government, and therefore are also labeled as a U.S. taxpayer of the federal income tax created by the 16th Amendment. Statutory U.S. citizens have no inalienable rights. The other group of U.S. citizens are those we refer to as American nationals. We use American nationals to avoid the confusion of the 2 types of U.S. citizen. This is a non-statutory expression. It's intentional to keep you from being drawn into an inaccurate understanding of exactly who you are in the eyes of the national government. By birth in the constitutional republic, you're a secured party to the U.S. Constitution. Here's some legal information that's never included with the Form SS5 that each mother should consider before signing that Form SS5 and its relationship to the federal income tax that was only created for application within the 10-mile square U.S. territorial jurisdiction. Previously, we addressed Administrative Regulation 26 CFR Section 301.6109-1 G1I, starting with A1, Taxpayer Identifying Numbers. This regulation has no enforcement authority to support it, as it's used only as a guideline for those working for the national government. It states in part, General Rule Social Security Number. A Social Security number is generally identified in the records and database of the Internal Revenue Service as a number belonging to a U.S. citizen or resident alien individual. The word generally means usually, according to custom or established practice. It does not state that at all times that's when an SSN actually identifies. But guess what the IRS will choose? You guessed it, the IRS will simply infer the holder as one who's subject to the territorial jurisdiction of the national government, where the 16th Amendment only applies. Something else that's interesting on the establishment of an SSN, it's also used to identify foreign persons under B, requirement to furnish one's own number. This number only belongs to the national government as it's their property, and you, the user, are gaining a purported benefit for referring to it with your name. The benefit is a tax imposed for the Social Security Act's retirement plan. Have you ever figured out the amount of payments you make over a lifetime for the federal income tax and the Social Security retirement plan? If you did, you would have found out that by simply putting that amount toward an investment that, when you retired, you would more than likely be a millionaire with compounded interest and principal being all yours and under your control right from the beginning. Getting back to the administrative regulation subsection 26 CFR 301.6109-1B2 III, where it states, a non-resident alien treated as a resident under section 6013G or H. Treated means taxed. This subsection is based entirely upon a voluntary election, but one without the government providing any full disclosure of the terms and ramifications of such an election. Thus, the election under 26 U.S.C. section 6013G or H is without willful and knowing intent. Here's what you find under IRC section 6013G, election to treat non-resident alien individual as resident of the United States. The non-resident alien will be treated as if they were a U.S. resident alien when they file a Form 1040 U.S. individual income tax return as part of the IRC of 1954 and currently the IRC of 1986 by A, under Subtitle A, Chapter 1 for that taxable year, and B, for purposes of Chapter 24 for payments of wages made during such taxable year. We have a revocation of election process that provides you with the option and blessing of the U.S. Congress to permanently leave the U.S. tax club. All this and a lot more all happened because the parent or parents of the newborn in the hospital listened to someone who was an authority figure present them with a Form SS5 to complete before they left the hospital. The child who was born in the constitutional republic was immediately converted into a U.S. taxpayer by being labeled as one secured with an SSN as part of the obligation to eventually file and pay a federal income tax. Thus, the federal income tax and the SSN are linked by those who are unaware. One additional discussion needs to be presented. What's a non-resident alien individual? We have a video on this subject, and due to time, you need to listen to it as well. Basically, a non-resident alien is one who was born in the constitutional republic, which is to say, an American national who does not work for the national government in any of its myriad of public offices. The newborn child is certainly not of age to even begin to be aware of what has transpired. The parents are too busy admiring their infant to focus on what they've just done as well. The administrative regulation shows the duality of locking the applicant into either or both choices. If you can eliminate the U.S. citizen component, the regulation still shows that the newborn can be labeled by the U.S. government as a U.S. resident and thus a U.S. taxpayer. The reason for the national government doing all this is to be able to legally impose the federal income tax upon the child in the future. They grow up brainwashed, just like those who centuries ago believed the earth was flat. The national government can only do so if that child is identified as either a statutory U.S. citizen or resident alien individual. Thus, to avoid the appearance of violating the Supreme Court's Pollock decision, Congress created the 16th Amendment, which ignored or omitted any inclusion to the rule of apportionment. A federal income tax is a direct tax and can only be levied within the constitutional republic upon the various state legislatures to collect said tax from their populace under the rule of apportionment mandated against the national government. The Supreme Court declared that any attempt by the national government to levy without consideration of the rule of apportionment was an unconstitutional act. In conclusion, the Social Security Administration created the SSN under FDR's administration when World War II was the main concern on the minds of American nationals at that time. The government used it as a tool to secure as many American nationals as possible to be drawn sub silentio within their territorial jurisdiction in order to tax them with the income tax, and at the same time, not violate the Supreme Court's Pollock decision or the U.S. Constitution. The Social Security number, just like the federal income tax, is completely lawful within the jurisdiction to which it was established to be operational. However, if you were to ask the Social Security Administration to withdraw your application for any reason, including that you were a minor when the document was created, you would be told that you can't leave the program due to the status of being a holder of an identifying number. Without doubt, the Social Security number is completely voluntary for American nationals, as it's not required by law or by the Constitution. Have you thought to ask, where's the law that will allow the Social Security Administration to state otherwise if you elect to leave the tax club? Such a law does not exist. A proclamation, if it were made by the government, would be a violation of the Supreme Court's Pollock decision for imposing a direct tax without the inclusion of the rule of apportionment. Of course, the parents of the newborn are never presented with this information. The Form SS5 is not a contract either, as the child was not of legal age, and there was no full disclosure what will transpire in the future by having such a number. There simply is no willful and knowing intent due to the lack of full disclosure by the government. Another important fact is that slavery is outlawed within the constitutional republic, but not in the territorial jurisdiction of the national government unless Congress has stipulated such for that jurisdiction. By the way, there's a Supreme Court decision, Fleming versus Nestor, which states in part, "To engraft upon the Social Security system a concept of accrued property rights would deprive it of the flexibility and boldness in adjustment to ever-changing conditions which it demands, and which Congress probably had in mind when it expressly reserved the right to alter, amend, or repeal any provision of the Act." The Supreme Court decision shows that there really is nothing permanent about the expectation of old age retirement benefits under the Social Security program. However, many would probably receive some payment even if it barely bought a decent meal once a month. This all makes it easy to see that the intent of Congress was to create yet another form of taxation upon those subject to their jurisdiction, and to draw in as many American nationals as possible. When an American national doesn't challenge the use of the Social Security number, it's required to be put on a federal income tax return as if the party filing that return is born in the territorial jurisdiction of the national government, or is a foreigner from another country. Once you leave the U.S. tax club or never enter it, the Social Security number can be returned to the government as it's federal property for use only in association with those government programs. The funds saved over a lifetime of work can be put into an investment vehicle outside the U.S. if need be, so that by retirement age, each American national can live a very comfortable retirement and even retire early in many cases. Is this the action of a benevolent government? Only you can make that decision. This video is provided for your educational awareness. The federal laws for those who are legitimate U.S. taxpayers should be complied with. For those who are American nationals, born in the constitutional republic, any attempt at fraud on the part of the national government is repugnant to the intent and foundation of the U.S. Constitution. We have many more educational videos located in the resource center of our website, Weiss+Paris.com. Questions can be emailed to us at bilateral@gmx.com. Click the thumbs up button if you found this video informative and subscribe to our channel. Thanks for watching.